With the above observation, LPS stands allowed.
वैसे भी 38 में भी तो नहीं समझ लिया था, यही करने को एकदम बता बात करनी है।
Your Lordship,
Kindly permit me to mention, Millard. Serial 38.1, Millard.
38.1.
That's kindly 1 week time may be granted because learned senior counsel is not well, Millard.
My lord, I am appearing in the first case. They had taken consent. I have conveyed to my lord that the matters may be segregated in going by the last order that has been passed with this honorable court and the officials who had appeared before this honorable court. I have reasons to believe it has become infructuous now. It was an undertaking to the effect that the licenses have not been cancelled of the deed writer.
Let us see the file when
My lord, yes, my lord.
Your Lordship, in serial number 31, Your Lordship, I am for the state. No one appears on behalf of the state has been.
Yes, it is.
Your Lordship, I was in another court. I
We
came.
can't help. We can't help. In old matters, there is no representation from the state. Yesterday, we have already informed your learned advocate general. Still, you people are continuing the same attitude.
Serial number 35, AK Pandey versus the Union of India for the Union Chief Shahid Ahmed.
You are for respondent.
Balance.
written supervisor that he has got a firearm and 100 rounds and he can use it. Firearm and 100 rounds. Firearm and 100 rounds of ammunition, and he can also use it. Same way to military minister.
That is Mr. BK.
You.
But he has not.
Third this time.
Then which are the other corroborative evidence?
Other three witnesses.
Three witnesses.
Three witnesses
Who are present?
And second child will also be he
So through other witnesses, it has been proved. So nothing.
and earlier
Charge number 3
minor punishment and
or charge number 3.
yes, charge number 3 is
Time was already. It was inquired into.
charge number 3 is nothing but a statement of that he was earlier promised one major matter was inflicted upon him and 11 times he was visited final court. And used the word indiscipline, negligence towards duty, responsibility. And
So in NPA, the only point raised by him is that Bouquet Aura has not been
the big Yora was not yet
remained last time.
Yes, he did not support the case, and this was no charge. Charge number 3 was no charge. It was just.
None appears for the appellant. In order to give one opportunity, release this matter after 2 weeks. If there is no representation on behalf of the appellant on the next date of hearing, appeal will be dismissed.
Serial number 36 is passed over for the day. Serial number 57, Yudhendra Prasad versus the State of Others for the Pelion Street Jagannath Singh.
What happened to the criminal case?
Criminal case is pending, when charges have not been framed.
Huh?
Charges have not been framed.
Original record is required.
What is the charge memo? Where is the charge memo?
Charge memo is Milord Annexure 2. Sorry, Milord, Annexure 1. To the writ petition, Milord, at page 23. At page 23, Milord.
What was the post held by the petitioner?
Milord, the petitioner was jail superintendent.
Jail superintendent. Jail superintendent was sent to jail.
No, he was not sent to jail, Milord.
Criminal case.
No, he on anticipatory bail he is running.
On what ground you are challenging that?
Milord,
What is the punishment? Dismissal.
dismissal.
What ground you are challenging?
Milord, I have to challenge the charge memo On the ground
You are
that,
challenging charge memo.
yes, my lord, that too I am challenging.
Charge memo on what ground you are challenging?
Lord, it has been issued by the same rank officer.
Same rank officer.
Same rank officer.
Jail superintendent.
My lord, it is joint secretary who has issued the charge memo. He is holding the same rank post, my lord, which the petitioner was holding.
Then according to you, who is the disciplinary authority?
The state government, my lord.
How state government?
Because the dismissal order, if my lord would be pleased to see the dismissal order,
No,
that,
on behalf of state government only, joint secretary will pass the order.
my lord, on behalf of the state, my
He is
lord,
one of the delegates.
under Article 166, my lord, any order has to be issued under the name of the governor, my lord.
It is not there.
No, charge memo is not there, my lord. The dismissal order is there under the orders of the governor.
But charge memo is not under.
The second challenge is, my lord, that the charge memo is fake. That I have raised before the inquiry officer, and subsequent thereto by Annexure 3, they have corrected the charge memo, my lord, may kindly see.
So they have issued a corrected charge memo.
My lord. Subsequently,
Then they have cured the defect. On what date? The first charge memo was issued on what date?
my lord, the first charge memo was issued
11/1/2013. 11/1/2013.
When it was modified?
Annexure 3, dated 28 to 2012.
28?
2012.
2012. After inquiry was
2013, my lord.
2013, wrongly typed in the petition.
90,
sir, within 1 month they have corrected. 1 month, few days.
no, after 7 months.
No, whatever. Sir, January 2013.
Yes, my lord.
This modified is in
August.
February 2013.
August.
August. What is wrong here?
Lord, the wrong, the period for which I was being charged, I was not posted at the jail concerned.
No, that is on merit. Insofar as you have said that joint secretary is not the competent
Yes,
authority.
joint secretary has not been corrected. This honorable court, while my lord hearing the writ application, my lord, if my lord would be pleased to see,
It is not in the name of governor.
See about that disciplinary authority this decision.
No, it's all right. But the signature, it should be in the name of by and in the
Yes.
name of governor.
Yes,
It is there.
यह राज्यपाल के आदेश Annexure 14
Annexure 14 is this.
आपके
That has been issued under the signature of the governor.
No, he's saying initial charge memo.
Annexure 1, I am challenging.
charge and dated 2nd of January.
No, 11/1/2013. He is saying 11/1/2013.
IG of the prisons.
IGF prisons. He is saying joint secretary.
earlier.
No, we are concerned with earlier only. The earlier charge memo was issued by Joint Secretary alone.
It was not child, it was initiation of departmental proceeding.
No, that is the along with that only charge memo is issued.
Kagaz-Patra is actually put in. So it was along with this, the child memo and evidence.
No, charge memo is signed by some other person.
Child memo is signed by
How can you?
Secretary General of Police.
Where do you?
Yeah.
No, with what material you say that jail superintendent appointing authority is government?
My lord, this question I have raised in the writ petition. The Honorable Single Judge, while hearing.
Sir, where is the material that the post of a jail superintendent appointing authority is government?
My lord, that has been considered by this Honorable Court Annexure 1 to the LPA, latest patent appeal.
You have produced the material.
I have argued the, my lord.
No, you might have argued where is the material.
Material, my lord, my client has also raised in the objection that the charge memo.
Sir, have you understood?
Yes, my lord, I have understood.
Under this, there must be rules, and in that particular rule, there is a schedule declaring who is the appointing authority, who is the disciplinary authority, who is appellate authority, who is the revisional authority. Where is that document?
Document, my lord, I have not brought on.
Then without that, how can we decide?
Lord, if my lord may allow me, I will produce tomorrow. And the second thing, my lord, for my lord's consideration in this case is that no witness has been examined to support the charge. My lord, the entire charge is based on the.
So shall we ignore the competency? Then don't argue piecemeal.
Yeah.
One of the contention raised by the appellant in the present case is that appellant is a holder of the post of a jail superintendent. His appointing authority is a state government and not head of the department or any other authority. This legal contention has been raised in order to interfere with the charge memo dated 11/1/2013 covering letter was issued by the Joint Secretary of the concerned department along with the charge memo, a statement of imputation, a list of documents and list of witnesses was stated to have been issued by the DIG.
Joint Secretary. IG.
IG prison only.
IG Prisons, IG Prison Department. Release this matter next week.
2 weeks, my lord. In the meantime, I collect the original record of this procedure.
2 weeks. In the meanwhile, you also ascertain who is the appointing authority insofar as jail superintendent is concerned. And by one authority frame the article of charges and forward it to the government, and government issuing a postman work.
Yes.
Serial number 38, Rupesh Kumar others versus the state of Bihar others for the appeal Sri Maneuvers.
We have partial duties.
Where is the Bihar deed writers licensing rules? 1966.
Manual, my lord. Bihar Deed Writers Licensing Rules 1996. However, before, my lord, the matter is placed, if I may request, my lord, to refer to the order dated, rather peruse the order dated 10/2/2020 passed in the instant writ petition, in the instant LPA, my lord. 10/2/2020. The matter pertained, my lord, to cancellation of the licenses of the deed writers.
No, this permitting you to decide the duties of the deed writers
My lord.
is subject to result of the present LPA. Such condition is imposed.
No, what has been stated here, my lord, is Shri Kartikeya states, he is the IG registration, my lord.
Huh.
The cause of the deed writers who are writ petitioners and the present appellants stands redressed for
Stands redress means closed.
meaning thereby, my lord, yes, the licenses have
No,
been,
where is the permitting you to discharge the duties of the deed writers? After cancellation, initially they are cancelled,
my lord, yes.
and thereafter restoring.
That, my lord, yes.
Where is the restoration order?
That was stayed by this honorable court in the connected writ petition, my lord. And thereafter the final order.
Restoration has been stayed.
Cancellation was restored, stayed, my lord. Initially, when the licenses of these deed writers, my lord, was cancelled, we challenged that in the connected writ application, that
Now-
operation of that was.
Now, what is the basis for making this statement on behalf of the state government?
They themselves say, my lord, that they are perhaps not taking. It is for this reason I wanted to point this out. That
Where is the order?
Your Lordship, the order was stayed earlier.
Stayed, all right, sir.
Your Lordship.
the stand that has been taken by them before this honorable court, my lord, suggests
Has been restored.
if it file an affidavit and clarify this, my lord, if they have already.
The other writ petitions are pending, cancellation.
Other writ petitions have been allowed in favor of the deed
No,
writers, my lord.
stay is in which order?
They have been allowed. In our case, my lord, stay was granted. Thereafter, we lost the writ application. We filed the LPA. In other cases, and thereafter, an LPA also stay was granted. Other writ petitions that were filed against cancellation of their licenses, my lord, they won it. The writ petitions were allowed. In this case, my lord, the learned single judge has differed from those earlier orders and relying upon an earlier order passed by him that he has passed the instant impugned order. Like there are different sets of, my lord, writ applications filed. Some sets they won it on the same facts. Whereas the learned single judge.
Redressed, Your Lordship.
Huh?
It has been redressed. The deed rights
So it has become infectious. Shall we record?
If it is for this reason alone, I am pointing it out. If that may be recorded on behalf of the state, my lord, after that we don't have any cause subsisting here. If state says that they are not going to take any coercive actions and their licenses stand restored, we don't have a case.
File an affidavit.
This is what I was presenting.
And what happened in CWJC 6078 of 2016?
That case was allowed in favor
Was
of
allowed.
the deed writer.
That has, I believe, my lord.
Coordinate bench.
My lord. Two coordinate benches, my lord. Some of the writ applications earlier were allowed, whereas the present order, my lord, which is impugned before this honorable court, the learned single judge has sought to differ with the set judgments on the ground that 9(1)H, the rule 9(1)H of the deed writers rules, my lord, licensing rules, they have not been taken note of in the right perspective.
Take on learned state council, sir, concerned respondent is hereby directed to file an affidavit to the extent whether the present LPA still subsists or not in the light of the order dated 10/2/2020 of this, the order dated 10/2/2020, which Sri Amir Subhani, Additional Chief Secretary, the then Additional Chief Secretary, Prohibition, Excise and Registration Department, and Shri B. Karthikeya, the then IG Registration, who are present on 10 to 20, and based on their statement, order has been passed. To that effect, affidavit be filed on the next date of hearing list after 3 weeks.
CR number 39, the state of Bihar and others versus CR number 39, the state of Bihar and others versus Pawan Sharma for the appearance Shri Mrityunjay Kumar.
Your Lordships. Pursuant to your Lordship's last order, dated 25th of February 2023, we have filed a supplementary affidavit bringing on record the ACP rules, your Lordships. Present memo of appeal is directed against the order dated 15th of May 2017.
Where is the scheme?
Annexure A to the supplementary affidavit, your Lordships. At page number 11, the relevant would be page number 15. The supplementary affidavit that was filed on 15th of March 2023 and hard copy on 17th of March.
Where is the criteria?
4. Page number 15, 4, your Lordship, an explanation, Roman 3. May I place that for your Lordship?
Correspondent is not replied.
Explanation is Roman 3, your Lordship.
Regular proportion.
And
Some other organization.
it has been explained in below, your Lordships. In Roman 3, it has been explained.
Where was he working earlier?
In transport, BSRTC, your Lordship, Bihar State Road Transport Corporation on ad hoc basis. 8 to 1989. 1989.
89.
And in junior accounts clerk, he was brought in government service on 13/8/1993.
13/8.
1993.
Now ACP is this is ACP.
Yes, your Lordship.
ACP for 10 years.
Yes, your Lordship. First was for 12 years and after that 10 years, your Lordship. It was granted, he was superannuated on 31st January 2016. Second MACP was granted on 24/8/2013.
So first ACP is entitled to 2005.
Yes, your Lordship.
That has been granted.
Yes, your Lordship.
Now he wants to count from 89.
Yes, your Lordship.
No, so observe that. What is the date? 93.
Lordship may kindly come to order number 5, dated 6th of February 2019. Past date present LPI, Your Lordships.
How he entered the government service as a accounts clerk, junior accounts clerk.
There was a scheme of, there was a circular of the state government, Your Lordship, pursuant to which he was absorbed by letter of district magistrate collector Motihari, while letter number 825 dated 13/8/1993.
Who is the respondent? He is not appearing.
Your Lordships, that is why Your Lordships, order number 5th, dated 6th of February 2019 may be seen. Notices were issued. He has refused to accept that, Your Lordships, and that was deemed to be validly served, Your Lordships.
It's in the instant. Perusal of the order sheet, it is evident that there is no representation on behalf of the respondent Baban Sharma, and matter is of the year 2017. Therefore, we are compelled to pass order in the absence of counsel for Baban Sharma or his presence. Next, the state of Bihar appellant has assailed the order of the learned single judge. Order of the learned single judge dated 25/2017, passed in CWJC 7216 of 2017. Respondent Baban Sharma, in his writ petition, he has sought for the following relief. The right of relief sought in the respondent is entitled to have the benefit of ACP with reference to service rendered as a conductor in BSRTC with effect from 8/2/1989. While counting the 12 years of service, or is he entitled to have the benefit of ACP benefit with reference to absorption of his service in the post of a junior accounts clerk, Motihari in the state service with effect from 16/8/1993 or not?
13/8/93. 13/8/1993.
13/8/1993. Crystal. Brief facts of the case are that respondent Baban Sharma was appointed as a conductor in BSRTC on 8/2/1989. Crystal. His services were absorbed against a junior accounts clerk, Motihari, in the state government. Which department?
In district collectorate, Your Lordships.
The district collectorate on 13/8/1993. Full stop. He had filed CWJC 18523 of 2011 for the purpose of counting past service for pension and promotion. He has attained age of superannuation and retired from service on 31/3/2016. He had been extended ACP benefit on 7/10/2016 while counting the service with effect from 13/8/1993 as and when he entered the post of a junior accounts clerk, Motiari in the office of the district collectorate, while ignoring the service rendered as a conductor in BSRTC during the intervening period from 8/2/1989 to 12/8/1993. Thus, he was aggrieved and filed a representation on 31/1/2017 and 1/3/2017 respectively. In not considering the grievance of the petitioner, respondent, he has filed a CWJC 7216 of 2017 and it was allowed to state feeling aggrieved by the order of the learned single judge present at the LPA. Learned counsel for the appellant state vehemently contended that the learned single judge has committed error in not noticing the criteria for the purpose of extending the benefit. In other words, service rendered in the post of conductor in BSRTC during the intervening period from 8/2/1989 to 12/8/1993 cannot be counted for the purpose of extending ACP in the light of the criteria laid down. The facts are not disputed.
Supplementary, Your Lordship. Supplementary in the present memo of appeal itself.
State government evolved rules called Bihar State Employees Conditions of Service Conditions within bracket Assured Career Progression Scheme bracket close rules command 2003 in bracket for short rules 2003. These rules 2003 has been given effect from 9/8/1999. The rule 2 in bracket 1I is relating to cadre. A definition of cadre. Just below that, cadre means a service or a group of posts as a separate unit. Further, it is necessary to take note of the fact that first ACP is required to be extended to such of those employees who have fulfilled 12 years of service as a regular employees of Group B, capital B, C and D of the state government. Who have not got the benefit of any financial progression during their career. In such circumstances, first financial progression and second financial progression
In the year 2009,
would be extended as and when employee completes 12 years and 24 years.
Your Lordships, there is slight bit of prayer before Lordships. In 2009, a fresh scheme MACP, according to which second will be granted after. Okay. In second, it was granted after 20 years of completion. Second MACP.
That is with reference to his entry into government service only.
Haji, that will be given after 20.
That concerned with the foundation, sir.
Haji.
Further, eligibility and condition prescribed under the scheme stipulates that concerned employee has been working in the same scale of pay, including the revised scale for the prescribed period of 12/24 years. Okay. It is necessary to reproduce paragraph 4 of the scheme, which reads as under. It is on page 44 of paper book LPA. Supplement. Paragraph 4 read with Roman 3 of explanation suffice to hold that 12 years of service is required to be counted in a particular cadre and in a department. Therefore, services of the respondent as a conductor in BSRTC cannot be counted for the purpose of extending the first ACP as and when he completes 12 years with reference to service rendered as a conductor in BSRTC. On the other hand, 12 years is required to be counted only as and when he joined as a junior accounts clerk in the collectorate of Motihari. It is on 13/8/1993. So these material information have not been taken note of by the learned single judge by passing order on 15/5/2017 CWJC 7216 of 2017. Next, in the light of these facts and circumstances, the Lord Single Judge has committed error in allowing the writ CWJC 7216 of 2017. Accordingly, order of the Lord Single Judge dated 15/5/2017 passed in CWJC 7216 of 2017 stands set aside. The LPA is allowed. The result, CWJC 7216 of 2017 filed by the respondent Baban Sharma stands dismissed.
Highly obliged, Lordship.
petitioner want to withdraw his application.
Next witness. And here judgment between serial number 1 to 7.
First of all, is it double court, roster?
This one. Which office will verify it? He, according to him, it is from our roster. And here judgment between serial number 1 to 7. And here judgment between serial number 8 to 13.
Serial number 8. Lordship, serial number 8 kindly.
Serial number?
8. Lordship.
हाँ.
कितना टाइम जाएगा?
एक सप्ताह.
1 week.
Serial number 15.
8 to 13. And here judgment between serial number 14 to 20.
15, my lord. Item number 15. I prefer 4 weeks time for filing the substitution petition, my lord. Because I'm for appellant, my lord.
Substitution.
Appellant is permitted to file application for bringing errors of the appellant petitioner
Ballot item number 20.
after 4 weeks.
All right, my lord.
Ballot item number 20, only pass over for detail. Pass over for detail.
Pass over.
Serial number 17, pass over for that day.
Pass over.
And here judgment between serial number 21 to 26.
24 minutes. Pass over for detail.
Pass over.
24.
And here judgment between serial number 27 to 34.
Serial 31, you say I pray for Passover only.
Pass over.
28 will only.
28 क्या?
2 weeks.
And here judgment between serial number 35 to 41. The heading to be concerned tied up serial number 1, Dr. Pandey Vinay Krishna Sahai versus the state of
Outside this, one more outside this, Lordship.
Huh?
Contempt matter, Lordship. I want to list this urgency there.
One with application.
My lord, in pursuance of my lord's order, put up this case on 12/12/22, but till date is not been listed here.
My lord, in my case also,
My lord,
my case also there was direction to list in
on
April 2020.
70.
It is listed before you.
No, which red petition is of which year?
My lord, it's a hearing, it's an admitted hearing matter. It has been assigned to your lordship, my lord.
Here, sir.
2016, my lord.
Please speak.
I'm so
हुजूर ये 17 का है, हुजूर का डायरेक्शन था कि एडमिट करके 9/11/22 को ऑन इट विल बी हाउड रिलीज्ड ऑन 9/11/2022 इसको हुजूर हियरिंग
Same matter, my lord.
ऑर्डर लगा दीजिए.
Lordship, order from which this contempt arises, your lordship, was that to settle the dispute of the petitioner within a month, your lordship. And ultimately, your lordship, by annexure A to show cause,
What is the dispute?
dispute, your lordship, with regard to payment of the period in which payment with regard to the period in which petitioner in pursuance of a status quo order, your lordship, continue. They are saying he was not continued. The order of a status quo.
You are appearing for respondent.
Yes, sir.
Now, what is your version?
In the petition, the petitioner has raised 5 claims, your lordship.
Have you considered and passed order?
Yes, order has been passed. We have
That order.
yes, annexure A to the counter affidavit, your lordship.
Though in pursuance of a status.
Yes, your lordship.
Complaint.
Lordship, in that regard, what they have said, Your Lordship. So far, those period which petitioner has continued in pursuant to the status quo order, it has been passed in June 2020, Your Lordship, and he has retired. On 28th February.
You agreed you challenge it.
Correct, Your Lordship. In that consequence, that person, so I am making submission, Your Lordship, that in paragraph number 7, they have said that since he has not vacated the government residence, Your Lordship, that's why he has not been considered. And second part, so dynamic is correct, Your Lordship. So far, dynamic ACP is concerned. No, I am not suggesting. Rather, I am submitting, Your Lordship, that I have already vacated the residence, Your Lordship, on 25th. Only this much. I just, Your Lordship, only this much my submission, Your Lordship, may take note of in order to Your Lordship, that he has vacated the residence on 25th to 2023.
Vacated, go and inform the authorities, sir.
That's why, that much observation I want. So far, dynamic ACP is concerned.
When did you vacate?
25th to 2023. And so far dynamic ACP is concerned, they have said, Your Lordship, that the requisite paper had not been submitted. That I have already submitted on 6/6/2018. And a reminder has been given on 28 January 2023.
28
January 2023. A reminder has been given with regard to dynamic ACP.
January 23.
Lordship.
You have furnished material.
Yes, Your Lordship. With regard to dynamic ACP, Your Lordship.
But they have not stated anything in this Annexure A 27.
He has stated that to submit the required information in prescribed format.
Only
then we will proceed with the payment of dynamic.
Yes, that I have submitted, Your Lordship.
For your order dated 27/2/2023. And Annexure A to the counter affidavit. The evidence that there is a complaint to the sublime counsel, the submitted that Peter has vacated the orders on 25/2/2023, and his grievance and it is pending consideration. Concerned authority is hereby directed to redress the of DAC within a reasonable period of time. Contempt petition stands dropped.
DSCP and salary, Your Lordship. And salary.
Salary, we have stated that he is unauthorized absent for the period, so he is not entitled for the salary.
No,
that part may not be recorded.
Yes, sir. Inquiry has been held. Inquiry has been held for remaining unauthorized absence.
He has filed the writ application against the order of transfer. He has never joined on the place of transfer. He remained absent during the pendency of the writ application.
But to the petitioner to tell the order at Annexure A dated so and so.
Serial number 2, Sangeeta Kumari versus the State of Bihar for the petitioner Sri Ram Sevak Chaudhary.
May please, Your Lordship's order of Your Lordship stated.
Page number
1912, you page number 18. नहीं हमको इसको कुछ मिला है. The operative part, Your Lordship, at page number 19. While setting aside passing the order of the removal. Procedure in law on the event of cancellation of appointment of petitioner.
cancellation of appointment.
They have not even posted us, nor they have started any procedure for the vote.
File a fresh petition. In our order, in my earlier order, there is no direction for providing you posting.
Your Lordship.
So
now, Your Lordship, they in the so-called, they have said that collector has took up the matter. Now let the collector decide the issue within a considerable period.
Just take it from FIC.
In the so-called they have.
Respondent have not committed any contempt, so I will take a contempt action. However, effect of quashing of the impugned orders, writ petition, we take a note of for the purpose of taking a consequential action by the concerned authority within a reasonable period of time. With the above contempt and stop.
5.
Serial number 3, Sanjay Kumar versus the State of Bihar for the petitioner's request judgment.
Your Lordship, the order of Your Lordship was not complied fully, and again they have stopped the salary of the payment of petitioner, Your Lordship, from December. Now they are flouted the order containing para 6.
Salary has not been paid?
Your Lordship, now they have stopped from December.
From?
December 2022 to March 2023.
Petitioners are still working?
Yes, Your Lordship, they are still working. And there was a direct...
Your Lordship, this is fresh cause of action, Your Lordship.
No.
No.
No. Para 6.
Para 6.
That is full, Lordship.
Page 16.
Next page.
This fact has come today, Lord, to my knowledge, Lord. If Your Lordship may grant me further.
We'll grant you time.
Your Lordship.
Which authority has to pay salary?
The Deputy Development Commissioner.
Respondent number?
3, Your Lordship.
Huh?
Respondent number 3. 3.
3. Third respondent is hereby directed to comply para 6 of the order.
And 5 also, Your Lordship. Earlier that was...
Para 6. In the payment of salary to the petitioners is reliably done from December 2022. The petitioners have not been paid salary. The same shall be calculated up to date and payment shall be made to the respective petitioner within a period of 3 weeks from today, failing which salary of the fourth respondent would be withheld on the
Third respondent.
Third respondent salary would be withheld on the next date of hearing.
There was, Your Lordship, non-compliance of para 5 also, for which Your Lordship has called the respondent.
Have they filed counter?
Yes, Your Lordship. They have filed the counter affidavit.
Suppose we have filed.
Please examine.
Obliged.
Serial number 4, Ram Das Misra versus the State of Bihar for the petitioner's fee allowed and
May I please, Your Lordship? Pursuant to Your last order, they have not done nothing, Your Lordship. Till date, I have not been reinstated, Your Lordship.
But I am filing my supplementary so cause, my lord. My lord, in which I have said, my lord, SC-111 who has, my lord, father has died, my lord, on 13th, and Shraddh is, my lord, on 23rd, 24th, my lord. So, my lord, that's why, and order of Your Lordship of 15 was notified on 28th, my lord. So, my lord, the positive time we are praying for at least 2 weeks' time, my lord. And when he will come, my lord, back from the Shraddh of his father, my lord, only he can, my lord, mention that LPA case before the Honorable Division Bench, where the stay was granted, my lord, earlier up to 28, when, my lord, 22.
What is that you are saying? I am not able to understand.
I am saying, my lord, that we have filed a supplementary affidavit that the LPA in which the order of Indradev Dubey was stayed by this honorable court, he cannot mention because the SC-11, whose father died on 13th, he was, my lord, only his Shraddh is, my lord, the final Shraddh is, my lord.
We are not concerned with that. There is no other counsel.
My lord, he is it is his case, my lord. Had it been, I have mentioned as a GA.
Sorry, sir, we can't.
My lord.
Keep your secretary present.
Lord, at least 2 weeks, my lord. We will comply the order if we will not get, my lord, LPA. We will mention, my lord, case on Monday, my lord. Even yesterday, I have mentioned, my lord, before division bench, honorable court asked me to mention today. But my lord,
is seeking time on the score that the concerned council has the personal inconvenience in mentioning the matter. So, state is not depending upon sole council. They have other alternative arrangement. Other alternative arrangement could have been done by this side. Therefore, Sir Sanjay K. Agarwal, Secretary Water Resources Department, shall be present in the court in the event of not reinstating the petitioner into service on par with the Mahangu Yadav. Next week.
okay.
Serial number 5, Chandrasekhar Prasad Sinha versus the State of Bihar for the President, Sri Arun Kumar Sinha.
May please your lordship. Order of your lordship is at 18 miles.
Counter fight.
So cause has been filed. Order is been completely complied, lordship.
Writ application was filed, my lord, for MSCP in the grade pay of 7600, my lord.
Fast has been remitted. Fast. Fast of 5,000.
My lord. Writ application was allowed with cost of rupees 5,000.
I have no idea about lordship.
No idea. Then keep the concerned official present in the court.
Lordship, on 11/12/2017, MCP was granted, but later on, on 11/12/2017, MCP was granted to the petitioner.
No, it's all right, sir. Whether have you complied the order para 8?
That MSCP has also not been complied, my lord. I'm submitting.
On the basis of
Who has to implement? Which respondent?
Respondent number 4, opposite person number 4, man.
Both the respondents shall be present in the court for non-compliance of the order.
Lordship, order is fully complied.
Next week.
Number 6, Vijay Kumar Singh versus the State of Bihar for the President, Sri Arun Kumar Singh.
Order dated 7/2/2022, election 1. Directive portion is at page 13, has not been complied with.
Complied?
Not complied. Page 13, well,
Filing so far,
For filing show after 2 weeks as the last chance.
Serial number 7, Sri Nivas Ojha versus the State of Bihar for the President, Sri Arun Kumar Singh.
Same as
the order is fully complied, Lordship. Kindly see. In serial number 5 also, the region order had been passed at 147 page number, Lordship.
Where is the order?
Let's on the basis of only violation of principle of natural justice, that it was allowed, Lordship.
Where is the order, sir?
Lordship. That is page
at page 16, my lord.
operative order at Lordship, page 22. There was
21.
Page 21, Lord.
Same order.
MCP was granted, later deleted. It was allowed only on the basis of that the violation of principle of natural justice.
Cost has have you remitted the cost?
Lordship, then matter was.
Have you remitted the cost? Where is the acknowledgement?
I am going to.
Same order. The other order. Serial 5. Serial number 5. Same order.
The heading for orders and office notes, title serial number 8 is adjourned to 1 week. The heading for admission, title serial number 9, total pass on versus the state of Bihar for the petitioner fee Manish Kumar.
Order dated 17/1/2022 has not been complied as yet.
Lord, I'll say against action and not
Counter. Failing which adverse order would be passed.
Serial number 10, Anil Kumar Sarma versus the state of Bihar for the petitioner fee Ashok Kumar.
Lords, in this case, one interlocutory application is going to be filed on that has already been drafted, my lords, and affidavit, which is 2 days going to be filed. So 4 week time may be granted. For extension of time, it is going to be filed, my lords, for full compliance of the order of this honorable court, my lords.
Lord, my submission is that, Lord. My Lord, order is annexure 1, my Lord. They kindly see para 9, my Lord. That has not been complied with as yet, my Lord.
For which, my lords,
Petitioner shall be taken back to duty forthwith, subject to outcome of inquiry proceeding.
The application for what?
For extension of time for concluding the department petitioner. Today I have it.
We are not concerned with that. We are concerned with a restatement.
That has already been done, my lords. As per our instruction, my lords, by the opposite party.
I have not been reinstated, my Lord, as per my Lord direction of para 9, my Lord.
Where have you stated in your show cause that petitioner has been reinstated?
My lords.
On 15/3/2022, he has been taken back to duty. Annexure 2. What is that?
And on the same.
People don't read and come. You doing library here.
My lords, because my lords interlocutory application.
Sir, you have already produced the order.
My lords.
Don't read.
My lords, kindly pass over for that day, my lord. Just.
It is just irritating the court.
I'm sorry, my lords. Extremely sorry. My lords, paragraph 5 of my show cause, my lords, earlier.
But it is not supported by document, I say.
Annexure 2.
In the pleadings you have mentioned annexure 2. Whereas the documents are ABCD and even ABCD does not reflect the date.
My lords, annexure 2 of the contempt petition, kindly see, my lords, page 17.
17 of what?
17 of original contempt petition, my lords. MJC petition, page 17, annexure 2. in para 3rd, my lords, annexure.
Have to join this service.
आदेश की निर्गत की तिथि से योगदान की स्वीकृति प्रदान की जाती है. The joining of the petitioner has been accepted from the date of issuance of this letter, my lord. It has been mentioned in this paragraph 3 of the annexure 2, my lords.
The disciplinary authority shall be present in the court for non-compliance of order on the next date appearing next week.
My lords, I have filed IA petition for extension.
You can't extend beyond the, when question of extension is would arise if the time limit is
only for
surviving. Time limit has already lapsed. Where is the question of extension?
Only for concluding the departmental proceeding as a fresh as per your lordship's order.
Rejected. Your IA will be rejected.
My lords, that may be, my lords. But my lords, as per so cause, my lords, the joining has already been accepted of the petitioner.
All right.
Under the heading for hearing serial number 11, Kaisan Chaudhary versus the Central Bank of India and others, or the petitioner's reading of Sikh Jihad.
Lord, with respect to my lord, I invite your lordship attention to order dated 22/2018, by which the office was directed to call for a report with regard to the stages of the two criminal cases. Only, my lord. And then, my lord, the next order is 18/11/2023, by which I was directed the bank.
Records are not available. Records are not available.
Records are not available. I have filed a supplementary affidavit stating that it has been lost in fire in the regional office at and that was reported, my lord. And my lord, the order dated 9/12/2021 may kindly be seen, lord. Because of the non-compliance of the order dated 22/2018, which was not meant for the bank was directed to pay cost. Maybe if for non-compliance of 18/11, then the matter would have been different for bringing the record. But instead of that, Lord, for non-compliance of the order 2018, which was not meant for the bank, it was meant for the office and the petitioner also to ascertain.
Have you sought for recalling this order?
Yes, my lord. I have earlier I have filed the supplementary, but I have advised him to file IA just now has been uploaded, my lord, and it is with me, my lord. The hard copy. The hard copy is with me, sir. Although the supplementary, by way of supplementary, are these facts.
After 1 year, you are filing. 1 year, 3 months.
Supplementary was filed long time back, no?
Not supplementary, sir. Recalling this order.
2021, 19/12/2021 was the order.
That is the reason I am saying it is 1 year, 3 months.
Supplementary affidavit. Which did 11/1/2022. So only
1 year.
1 month. It is 9/12/20.
Sir, 9/12/2021 order. On what date you are filing application for recalling this order?
11/1/2022. Of course, not the petition, but by way of supplementary. When I have gone through the record, then I advised him to file a formal.
After 1 year, we will not entertain. What is the subject matter?
Subject matter is the departmental proceeding, Lord. The petitioners are not coming, Lord.
All right, we will decide. Where is the regulation?
Regulation is there. But the main grievance of the petitioner is that he could not have proceeded and the departmental ought to have stayed in view of the clause 4 of the regulation, my lord. That regulation has been dealt with in the Supreme.
This is the regulation?
Yes, my lord.
Then inquiry commenced under which provision?
It was under clause 4, my lord. It has been stated that clause 4.
Clause 4 is relating to prosecution.
Prosecution, if it is not put there, if he is not put on trial, then the proceeding may proceed.
So where is the charge memo?
The charge memo. This dates, my lord, I have prepared.
Where any criminal proceedings was pending?
My lord, that is why your lordship has been pleased to direct the office to ascertain what is the stage of the criminal proceeding.
You are not aware?
I am not aware, my lord. And my lord, interpreting the clause 4, the Honorable Supreme Court has held that there is no bar as such. It is not a mandatory to stay the proceeding. This very clause itself.
No, there is the interim order.
No.
Then why are you saying all those things? Not to stay the proceeding. They are not going to stay the proceeding.
They have.
Sir, we are already past that the stage.
Yes.
So then why are you saying all those things?
That is the grievance.
Where is the charge memo, sir?
Charge memo is Lord, the first writ petition I don't have because it was being dealt by another lawyer from where the records have not covered. The second writ petition may kindly be seen. No, first writ petition.
Sir, what is that court is asking you?
Yes, but the charge memo is.
Then why are you saying first writ petition, second writ petition?
29, my lord, of the first writ petition. There are two writ petitions, my lord. That's page 29, my lord.
In which writ petition you want to?
It is 6839/2003, my lord.
That only. Which page? Page number?
Page number 29 is the charge number.
29. Where is the supporting document and the list of documents, list of witnesses, statement of imputation?
That is the charge sheet. That was a memo prior to charge sheet, and then the annexure 3 at page 32 is the charge sheet.
I am not able to follow you. Sir, you say charge number, charge is page 29. I am asking you where is the statement of imputation, list of documents, list of witnesses.
The charge sheet is at page 32, where the details of the charge is given.
Where is the list of us? I am repeating for the third time, Mr. Counsel. It is not there. So on that ground itself, I will set aside the entire proceeding.
What I say that it is, it can be produced in the inquiry proceeding also. He has what he has objected to in response to the charge memo.
Charge memo or charge sheet must supported by statement of imputation.
Invite your lordship to page 34, where he has objected to the charge sheet.
34 is what?
34 is the show cause.
Reply. How is it?
Reply, my lord.
Relevant.
Not reply. He says that I will not answer anything because a criminal proceeding is going.
Forget about his version. Look at your conduct. You are not produced material.
Our records are not here, my lord.
Take it. Sorry, none appears for the petitioner. Matter is of the year 2003. When counsel for the respondent bank on inspection submitted that original records relating to inquiry proceedings stated to have been set ablaze in a fire accident. Therefore, he is not in a position to produce the original records relating to initiation of inquiry and its conclusion. So, perusal of records, perusal of the documents along with the writ petition, charge memo is not consisting of statement of imputation, list of documents and list of witnesses, support of the alleged charge stated in the charge dated 15/3/2001.
There is a supplemental charge also.
So there is not even reference in the charge memo. Full stop. However, the alleged allegation is that petitioner is stated to have manipulated the bank records insofar as the number of account holders while creating the credit entry and misappropriated bank customers' money. So, no doubt it is a serious charge leveled against the petitioner. At the same time, there are legal lacuna in initiation of inquiry. In the light of legal issues that charge memo is not consisting of statement of imputation, list of documents and list of witnesses, all further proceedings be stayed. Accordingly, petitioner has made out a prima facie case so as to interfere with the impugned orders. Lecture so and so, dated so and so. They are set aside. The writ petition stands alone.
There is one more writ petition. There is one more writ.
Same person? Same person.
I don't know what is the, because that file is not available.
The connected file.
What is the grievance raised there?
Connected matter, petitioner has prayed for the following relief. The grievance of the petitioner shall be considered in the light of the order, order passed in CWC 3/9 of 2000, in a period of 4 months from the date of receipt of this order. So in the event of petitioner is not entitled in such circumstances, a detailed speaking order shall be passed as to why the petitioner is not entitled to EPF along with interest. Accordingly, petitioner stands disposed. He has got to EPF.
But I pray, my lord, that the direction for cost may be recorded. So I am filing, my lord, just.
I will reject that also. Give the IA. Previous file. The CWJC 6, madam, in the CWJ 6839 of 2003, initially you take this, and counsel for the respondent filed interlocutory application to recall the order dated 9/12/2021. It is relating to imposition of cost of rupees 5,000. So there is a delay of more than 1 year in filing interlocutory application to recall the order dated 9/12/2021 on 22/3/2023. Accordingly, it is rejected.
Supplementary affidavit was already filed long time back. Soon after imposition of the cost.
Sorry, sir.
Senior Partner on Survey Alam versus the State of Bihar and judge for the petitioner Sri Sunil Kumar.
Lordship, this case comes under batch case and squarely covered under few has been passed by the Honorable Court. This case relates to the subject matter of the case is for the termination of services of the constable and
termination of
service after serving for a long years of 13 years and his service.
What is the date of termination?
The date of termination is 16/8/2003. 16th August 2003.
16/8/2003.
Yes, yes, Your Lordship.
Where is that order?
It is in the petition attached in Annexure 3.
Annexure 3.
Yes, Your Lordship.
Page number. Page 19.
Page 19, Your Lordship, yes.
Yes, Mr. Counsel. Is it a speaking order? Is he a permanent employee? Is he a permanent employee?
He was appointed as per the counter of the state government, Your Lordship. The petitioner was a backdoor appointee, Your Lordship. He was appointed by a DIG, Your Lordship. No police manual was followed, no appointment procedure was followed.
Correct, but there is no speaking order. It is not a speaking order. Whether petitioner has been heard in the matter. He was appointed on what date?
He was given a show cause notice. He
was appointed on what date?
He was appointed in 1991. 1991, Your Lordship.
4th January 91.
4th January 91.
Several cases of illegal appointment were recovered.
Sir, page 19. Whether is there any reference to show cause notice, reply of the petitioner? Then?
Your Lordship.
Matter may be remanded, Your Lordship. Matter may be remanded, Your Lordship.
Remanded, who is going to pay during the intervening period from 2003 to 2023 for 20 years? Who is going to pay? From your pocket, are you going to pay?
Your Lordship also would like to submit that this case is...
No inquiry has been held?
No inquiry has been made. Several appeal has also been made to the concerned authority like DIG and DG.
Appeal is also rejected?
Appeal, no reply has been given to the petitioner. No reply has been given to the petitioner after several appeals has been filed.
What is the date of your appeal?
The first appeal was filed to the DIG, which is in Annexure 4, dated 28 August 2003. That was the first appeal. And then the second appeal was also filed to the same authority that is attached in Annexure 5, which is dated 31st January 2004.
No response.
No response again. And then again a third appeal was filed to the DGP of Bihar, which is again attached in Annexure 6, which is dated 15th June 2004. June 2004.
The state of the instant petitioner has prayed for the following relief. The petitioner is stated to have been appointed on 4/1/1991 as a constable. In the year 2003, the police department noticed that initial appointment of the petitioner was not in accordance with law. Therefore, concerned authority proceeded to terminate the services of the petitioner on 16/8/2003. Feeling aggrieved and dissatisfied with the order of termination dated 16/8/2003, the petitioner has exhausted remedy of filing appeal and representation before next higher authorities on 28/8/2003, 31/1/2004 and 15/6/2004. There was inaction on the part of the higher officials insofar as redressing the grievance of the petitioner. In this backdrop, perusal of the records, it is evident that no inquiry has been held before terminating the services of the petitioner. It is to be noted that petitioner was appointed on 4/1/1991 and the termination is dated 16/8/2003. During the interregnum period, the petitioner has earned permanent status as a government servant. Therefore, before terminating the services of the petitioner, the concerned authority, disciplinary authority, should have resorted to initiating inquiry under the relevant disciplinary rules / regulations to stop. In the light of these facts and circumstances, petitioner has made out a case with the impugned order. Accordingly, impugned order is set aside. Concerned authority is at liberty to take further action, if any, and if it is warranted at this distance of time, such proceedings shall be completed within a period of 6 months from the date of receipt of this order. Next paragraph. Order of termination dated 16/8/2003 is being set aside on technical ground that no inquiry has been held and the matter has been remanded. In that context, it is necessary to take note of a decision of the Apex Court rendered in the MD/ECIL versus so and so and Coal India so and so, paragraph 46 to 50 reads as under. In fact, Supreme Court has reiterated the principle laid down by the Apex Court in the case of MD/ECIL in the later decision in the case of Prabhat Kumar versus the state of Uttar Pradesh, reported in so and so. What is the age of the petitioner?
Your Lordship, the petitioner has already superannuated, attained the age of superannuation.
Having regard to the fact that petitioner cannot be taken back to duty as he has already attained the more than 60 years to stop. Next, in the event of any proceedings is in favor of the petitioner insofar as the validity of his initial appointment dated 4/1/91 in a departmental proceedings. In that event, the petitioner is entitled to all monetary benefits from the date of termination till the final order to be passed by the till the date of retirement within bracket in the event of if he was in service. The same shall be calculated and disbursed within a period of 3 months from the date of receipt of 3 months from the date of passing a fresh order in a departmental inquiry.
Obliged, Your Lordship.
Serial number 13, Ram Bhagat Singh Bhagat versus the State of Bihar for the request to improve Maharashtra.
May I please, Your Lord? Lord, this is the second round of litigation. Lord, I am giving the list of dates. List of dates.
It is here.
Lord, a detailed, that is the more. Lord, the charge memo which is at Annexure 8 was issued on 17/1/89, my lords. The petitioner filed his reply. The inquiry, in the earlier inquiry, my lords, he was partly exonerated of some of the charges, my lords. Then, my lord, second so-called.
What is meant by majority of charges?
My lord, there were 2 charges.
No, majority. What is the word here? Majority. Do you know meaning of majority?
Large number of charges. It may be he was exonerated of some of the charges, my lord. It may be read like that. He was exonerated of some of the charges. My lord, second so-called notice, reply filed, there was order of dismissal was passed. Filed a writ petition, my lord, it was dismissed on the ground of delay and latches. Then he filed an LPA, it met the same fate. He appealed to the Supreme Court, the order was set aside, matter was remitted to the division bench, LPA for deciding it on merits. The LPA bench order is very important, my lords.
LPA was?
My lords, the LPA which was earlier dismissed.
It was restored.
It was restored by the virtue of Honorable Supreme Court. And the LPA bench, my lord, set aside the order of dismissal and made a limited remand, saying that on same inquiry report you pass a fresh order because he has been exonerated of some of the charges. Tentative, what, my lords, thereafter, my lords, they issued a fresh charge memo.
So where is this LPA order 1078 of 2000?
Annexure 23, my lords.
Annexure?
Annexure 24 at page 116 of my lord's brief. Lords, may I read it? In our view, there is non-application of mind to the disciplinary authority while passing the order of dismissal. In that view of the matter, the impugned order dated 20th July 1996 is set aside and the matter is remitted to the disciplinary authority to consider the matter afresh, taking into consideration the contents of the inquiry report. The result, the appeal is allowed and the order of the learned single judge dated so and so.
Have you challenged the charge memo?
Lord, earlier I have challenged.
Have you challenged the fresh charge memo dated 6/11/2000?
Yes, my lord. But my lord was not inclined to allow that IA on the ground of delay and latches. That my lord will find on the last order, my lords. But what I will submit, my lords, as far as the fresh charge is concerned, the order of remand, my lords, is to be seen whether the authority has transgressed the limits put by this.
Filed contempt.
My lord, I will not go into that. My lord, I will, my lords, on the merits I will argue. Let that point be. If my lord is not in.
So you will admit fresh charge memo sustains because you have submitted your explanation and you have surrendered your rights.
My lords. my lord, surrender your right, my lord, to that, my lord, submission would be waiver, acquisition will apply, my lord, against statutory law.
Then file contempt.
I will not go into that, my lord. I will go into the merits of the case. Why should I, my lord, go into all those things? And, my lord, thereafter, my lord, they initiated a fresh inquiry. My lord, no document was supplied. That is an extra 35. It does not contain, my lord, list of witnesses. It does not contain, my lord, list of documents.
Where is that?
That is with the IA which has been rejected. IA, my lord, has rejected it. That has been enclosed with the IA.
Insofar as challenge to that, it has been rejected.
My lord,
where have you produced this charge memo?
Annexure 35, my lords. That is with the IA. Next, IA number 1, my lords. Annexure 34 is the charge memo. Now, in the first inquiry, my lords, 3 witnesses were. Their written statement were recorded, were produced by them. They were not examined in course of inquiry. They were.
What is the date of document Alleger 34?
34, 6/11/2003, my lords.
Number?
3.
3.
Then, my lords, my reply was taken, and then in 7/1/2004, my lords, one witness, Uday Sankar Chaudhary, he filed a written statement in support of the charge. He was not examined, nor an opportunity of cross-examination was provided. Violation of 17(4), my lords. Again, another witness, his written statement has been brought on record, and he was not produced on any day in the inquiry. And then, my lords, a report was called from the district manager. And then another witness, C.R. Jha. 3 witnesses were examined in subsequent course of inquiry, my lords. And, my lords, thereafter, my lords, petitioner filed an application for supply of document. It was not given. And then after, my lords, a final. And what is more important, my lords, most important thing is, in the previous charge, my lord, I was exonerated of some of the charges. 556, it is alleged that there was misappropriation of 5,56,000 and odd. The inquiry officer said that out of 556, 2,10,000 has been sold by the department as a damage which has to be deducted from the charge.
We are not on merits. Cannot as an appellate.
No, what I am saying, that part of the charge was disproved. If you are saying that yes, you are still guilty for 556, a tentative ground has to be given, my lord.
We are not on merits. Sorry, don't ask us to say merit. Any legal issue?
My lords, only submission would be that, my lords, when you have held me guilty of the entire 556, and in inquiry, when the inquiry officer has held that out of
Have you seen the decision of the Apex Court, Guneshekar, and latest Umesh?
My lord, PNB and
writ courts cannot interfere on merits.
Not on merits, my lord.
You are saying on merits only.
Only I am saying that if you are differing with the inquiry report, that the inquiry report had exonerated on you part of the charges, then a tentative ground for differing ought to have been given, my lord.
Sir, but you have surrendered with reference to fresh charge memo. You can't go back to the earlier inquiry that I have exonerated.
In the second inquiry report, there is no finding regarding that 556, my lords. There is no finding regarding 556.
The
second inquiry report.
Second inquiry, there is no reference to
550 earlier charge.
Then why are you saying all those things?
In the second inquiry, there is no reference to the charge which has already been examined. It was in respect of fresh charges.
We need not go into that.
Okay.
You are not challenged the charge memo timely.
My lord, then these are the submissions that, my lords, there is a violation of natural justice. I was not provided an opportunity to cross-examine them. And documents, I have repeatedly been asking that they have not been supplied. And the third is, my lord,
where is the material that you have demanded the document?
My lords, yes, my lords. The report of the inquiry officer itself, my lords, the report I have asked.
Inquiry report not given?
No, inquiry report. Not.
Where is the demanded documents?
My lords. That is, my lords, at page 28, annexure 28, 122.
Page 122. Page 122.
My lords. No. 22/9/2004 letter, my lords. And one more important thing, my lords.
Sir, where is that?
My lords, at page 123, my lord.
Which are the documents you demanded by you?
My lord,
are those documents are relevant for the purpose of inquiry?
Relied upon were never supplied in course of inquiry.
Which are the documents relied on?
My lord,
they can't vaguely make statement. All the documents relied. ABCD, the title document dated so and so.
Lord, my lord has, my lord, seen annexure 34, my lords. In annexure 34, which is the second so-called notice, second charge memo, my lord, no document is reflected, my lords. Therefore, my lord, I asked for the supply of all the documents which were.
Where is the regulation which requires document is required to be furnished?
Yes, this is the rule.
Which rule is applicable?
Discipline rules, my lord. Bihar
is that rule?
Several times, my lord, direct to the petitioner to appear before the authority to collect the records, my lord. You want report.
Was the regulation?
My lord, my lord. बिहार से इसको मिशन बना के दिए थे ये सबसे हाँ ये सबसे मोटा बना के दिए
My lord, it may be passed over. I may also see the rule which he is saying relying upon. Just for one day.
How many years matter is pending?
Several times direct to the petitioner to appear before the authority and collect the documents, my lord. But petitioner never.
There are the regulation, Mr. You are representing.
My lord, Revolution earlier, my lord, is submitted, my lord, and again, my lord.
Without books and regulations, you people appear.
कल हम आपको
All documents supplied at the time of charge sheet, memo of charge, my lord.
फर्स्ट इंक्वायरी करें तो बोल रहे हैं कि देखेंगे नहीं आप
चार्ज के साथ चार्ज नोट करते हैं जो नवासी में दिए थे
What do you say?
My lord, at the time of charge, my lord, all documents, my lord, served along with memo of charge, my lord, page 74.
24. Writ petition.
Annexure 8, my lord, memo of charge 71, my lord, and evidence list, my lord, 74, along with memo of charge, my lord, 74. And prisoner's first time demand, my lord, 2004, again, my lord, 2004.
That is 24 is pleading.
74, my lord.
74.
74.
That was
71
first round.
they start held, 71 they start memo of charge, and list of evidence, my lord, 74.
That my lord said I will not see because it is the first round of.
Page number 17, and where is the list of documents and witnesses?
74, my lord, 74.
Page 17, sir, 6/11/2003, charge memo. You are pointing out earlier.
He is pointing out.
You are concerned with the 6/11/2003. Please apply your mind.
My lord, and second, my lord, page 133, my lord, can you see, my lord? 133. 133, my lord.
What is this 133?
Already mentioned by inquiry report, petitioners wanting some documents, my lord. Already stated, श्री बालक ने अपने आवेदन दिनांक 22/9/2004 द्वारा सूचित किया है.
So what is this document first of all?
Documents, my lord. Thereafter, my lord. No, any specific, my lord. Only for documents.
Sir, what is this document you are relying on? It is titled as what? Inquiry report or what is that?
My lord, detailed inquiry.
Very difficult to convince you people, sir.
Inquiry report, annexure 21.
Sir, we are not concerned with the inquiry report.
The order of dismissal.
Where is the list of documents?
List of documents, my lord, page 74, my lord.
It is relating to earlier.
Earlier memo of charge, my lord.
We are not concerned. Why are you going back? When you have already framed fresh charges on 6/11/2003.
सेकंड वाला कितना पेज होगा? 4 सेकंड चार्ज my lord, that documents not annexed in the writ petition, my lord.
What was the post held by him?
Assistant Godown Manager.
Assistant Godown
Manager.
He has followed the Godown itself.
No, my lords.
Sir, in the year 2003, allegation is relating to lakhs of rupees.
No, my lord. Allegation is
77, 78, 37,000.
Yes, my lord. That was for the period when allegation is that these food grain got damaged. And as a result, it is alleged that it will amount to misappropriation. This is the charge. It was wheeled. It was not properly killed. Our case was that roof was leaking and it was waterlogged area. This is what we have, and on our instance, my lord, the inquiry started. We made the complaint that roof was leaking. For last several months, we made a report to the higher authorities. And therefore, my lord, some of the products were sold in open market, and amount of 2,10,000 was realized out of those which damaged product, my lords. It is not a case of selling the product. It is a case where it got damaged. Wild. This is what they use. They use the word wild.
It has damages. We don't know. We are not the witness. We are not.
No, nobody. This is the charge, my lord.
Yes.
Lord, no witness was in the second inquiry. No witness was examined. Only written statement was taken on record.
That point, my lord, never raised my lord file application before the inquiry report, my lord. Only my lord, page 124, my lord, application.
Will convert the penalty from dismissal to that of compulsory retirement. Let him go. Take down in the instant petition. Petitioner has prayed for the following relief. The petitioner, while working as a assistant godown clerk, or what is that?
Manager, my lord. Assistant
godown manager. He was subjected to subjected to disciplinary proceedings. It was concluded in dismissal on 20th July 1996, and subject matter of litigation before this court in CWJC 5568 of 2000. It was dismissed. Thereafter, LPA 778 of 2000 was also dismissed. Further, he has invoked remedy before the apex court in civil appeal number 1941 of 2000, and it was allowed while restoring LPA 1078 of 2000. How can it be 1078? LPA 778
778. It is 778.
778 or 1078?
Just for 1 minute. 20 Alex to 24. Lord, it is 1078. 1078 is the correct number.
Also 1078. So to the LPA 1078 of 2000. And LPA was allowed on 29/9/2003. Petitioner was taken back to duty on 5/11/2003. So, concerned authority, next one, concerned authority, instead of implementing the order passed in LPA 1078 of 2000 to the extent that examination of inquiry report by the disciplinary authority and proceeded to pass order, the respondents have resorted to issuing of fresh charge memo on 6/11/2003. So, the petitioner, instead of filing instead of questioning the validity of charge memo or invoking contempt proceedings, he has surrendered his right before the inquiring authority insofar as facing a fresh charge memo dated 6/11/2003. Second inquiry was concluded in imposition of penalty of dismissal from service on 22/7/2005. Hence, they present a writ petition. Next, for learned counsel for the petitioner submitted that along charge memo dated 6/11/2003 statement of imputation, list of documents and list of witnesses have not been provided, and further he had demanded certain documents which were also not provided. So further submitted that about 4 witnesses have been a written statement has been taken by the inquiring officer without there being summoning them to appear in the inquiry and adduce the evidence. He submitted that all of the documents were required to be examined and cross-examined. On the other hand, evidence of the witnesses have been taken note of. The absence of providing opportunity of cross-examining such of those witnesses. Therefore, the impugned order of dismissal is liable to be set aside. So, per contra, learned counsel for the respondent resisted the aforesaid contentions and submitted that there are serious charges leveled against the petitioner, and it involves financial irregularities. Therefore, imposition of penalty of dismissal need not be interfered, since disciplinary authority has followed the Bihar State Food and Civil Supplies Corporation Service Conduct and Disciplinary Rules 2001. He also submitted that Rule 28 procedure for dealing with the case of misconduct has been strictly followed. So, heard the learned counsels for the respective parties. Matter is of the year 2005. It is to be noted that this is second round litigation with respect of alleged charges. The first inquiry was commenced on 17/1/1989 and it was concluded in imposition of penalty of dismissal on 20th July 1996. In other words, 6 years sorry, 7 years has been availed by the disciplinary authority to initiate and conclude the inquiry. Thereafter, it was subject matter for litigation on judicial side, and it has attained finality while remanding the matter on 29/9/2003. The disciplinary authority has committed glaring error in not implementing the order dated 29/9/2003 passed in LPA 1078 of 2000. In fact, he has committed contempt of a court order. However, it was not brought to the notice of this court by either of the parties. On the other hand, disciplinary authority proceeded to reinstate the petitioner on 5/11/2003 and proceeded to frame fresh charges, and it was concluded frame charges on 6/11/2003, and it was concluded in imposition of penalty of dismissal on 22/7/2005. It is a case for remand for the reasons that charge memo dated 6/11/2003 was not supported by statement of imputation, list of documents and list of witnesses, and further demanded documents on behalf of the petitioner are not provided to him, and further about 4 witnesses have been examined by means of obtaining written statement from them in the absence of their appearance in the inquiry, and providing opportunity of cross-examination by the petitioner. These are all, once again, the authority has committed error. In the light of these facts and circumstances, instead of remanding the matter, this court believes that in order to render justice, modifying the penalty of dismissal to that of compulsory retirement with effect from 27/2005, the date on which a petitioner was dismissed from service. No doubt, this court has no power to modify the penalty in the light of apex court decision. However, conscience of this court is shocking to the extent that disciplinary authority has committed blunder, committed glaring error in not implementing the order of this court passed in LPA 1078 of 2000 dated 29/9/2003. On the other hand, proceeded to issue fresh charge memo and concluded during the intervening period from 6/11/2003 to 22/7/2005. Therefore, it is a case for modification of penalty. Instead of remanding the matter to the disciplinary authority and asking him to revisit to the entire matter, and once again commencing the inquiry from the defective stage, like providing list of statement of imputation, list of documents and list of witnesses, along with the fresh charge memo, which were issued on 6/11/2003. Accordingly, impugned order of dismissal is dismissal dated 22/7/2005 is modified to that of compulsory retirement. The effect from 22/7/2005. The concerned official respondents are hereby directed to extend all monetary benefits which were due to the petitioner with reference to imposition of penalty of compulsory retirement with effect from 22/7/2005. To stop monetary benefits shall be calculated and disbursed in accordance with law within a period of 3 months from the date of receipt of this order, failing which is entitled to litigation cost. It is quantified at ₹25,000.
My lord. Petitioner retired, my lord, Jharkhand, Hazaribagh, my lord. That time, my lord, petitioner posted, my lord, 22/7/2005, my lord, 5/11/2003 to
22/7/2005. What?
Hazaribagh, my lord, Jharkhand, my lord.
Jharkhand.
My lord.
That order is relating to Jharkhand.
Order has been passed from Bihar State Patna office. It was a unified. It was bifurcation.
All right, but ultimately the Patna office is required to settle its service benefits. What is the?
Only for monetary benefit as per bifurcation order, my lord.
Only monetary benefits.
14/11/2000, my lord. Those employees are posted in the Jharkhand case jurisdiction, then all monetary benefit paid by the Jharkhand. After 2000, my lord. Before 2000, my lord.
You pass such order.
Issue already decided by the Human Rights Commission case, my lord. Issue already decided by Human Rights case, my lord, or order.
In terms of that, you proceed to pass order. Whatever the benefit which is required to be given by Patna office, you give it. Insofar as other issues are concerned, you write a letter to the counterpart.
Serial number 14, Nagendra Chaudhary versus Uttar Pradesh State Government.
My friend will assist, Lord. So I'll be.
Lord, this matter has come on remand from the Honorable Supreme Court. Earlier, this matter was disposed of by order dated 18/10/2019.
Lord, at the very outset, say, my lord, the records, records of the earlier writ petition, which was disposed of in
2019,
has to be placed, my lord, and then I will assist your lordships. So for that, I need some time.
All right, next week, at the request of the council for the respondent bank, to secure records. Yes, next.
Serial number 15 is adjourned for 4 weeks. Serial number 16, Santosh Kumar Diwakar versus the Union of India Brothers for the prisoners with leaders.
On the
appointment of presenting officer.
On the last occasion, your lordship have directed to provide a review of law for appointment of presenting officer. But
there is no provision.
There is no provision for appointment of presenting officer prior to 2011, and this case is of the year before the.
All right, even if there is no provision, we are bound by the Apex Court decision in the case of Union of India and other persons, Ram Lakhan Sharma and MD ECIL.
But my lord, the petitioner was given an opportunity for availing the services of.
We are not concerned with that. We are concerned with the only presenting officer.
My lord, I'm just showing you the circular by which after 20.
Your circular overrides Supreme Court order.
It is admitted position.
So we will allow the petition. We will remand the matter.
Lord, it is a fact that at that time when the departmental inquiry was going on, there was no provision in.
All right, sir. That has been taken note of on the last occasion. Supreme Court has held that in the case of Ram Lakhan Sharma, presenting officer is required. And further, MD ECIL case supports against you. The principle laid down in MD ECIL case, if the rule does not provide for providing second show cause notice along with the inquiring officer's report, still you are required to provide it.
The presenting officer is to represent the case of the department, your lordship, but on the other hand, he has the petitioner.
Who has presented the case in the present case on behalf of departmental inquiry? Then that is sufficient. Inquiry officer is biased.
But Lord, he has been given an opportunity for the defense assistance. This is important, your lordship, because he is raising this issue on the ground of natural justice. He was not given that opportunity.
Not a question of opportunity, sir. Procedure follow. Can I act as a prosecutor and judge? Can I come and over that place and take your file on behalf of you and take a decision? Courtmaster, we have passed a detailed order in identical matter. Where is that? Division bench. You don't know anything. You don't keep a record. There is no proper assistance from the court master.
It is LP and 982 by.
What is that?
Radhe Shyam Singh versus State of Bihar, no presenting officer of.
That is LPA?
Yes, ma'am.
Give that number. You just go through our LPA decision and you can come back on the next week.
LPA 982 of 2018, Radhe Shyam Singh versus State of Bihar, no presenting officer was there.
You take down that number, sir, and obtain a copy. Take home, sit calmly and read. Anything is required to be addressed to you. Then you make your submission.
Recorded.
LPA bench decision is binding on single judge.
Of 2018.
And counsel for the respondent is hereby directed to produce the decision passed in LPA number so and so in the case of so and so and apprise this court on the next date of hearing. This matter after 2 weeks.
By law.
Personal appearance of so and so stands dispensed. What is his name? What is the rank?
Sir, myself Sanjay Kumar.
Please come.
Second in command. Staff.
He is second in command here, lordship, here in CRPF.
Lot of assistance given to the court. His office is in Patna only.
My lord.
Sanjay Kumar, reception officer.
No.
Next.
Sanjay Kumar, second in command.
Second in command.
Serial number 17 is passed over for the day. Serial number 18 is to Neil Prasad Singh versus the chairman and MD Bank of India for the Christmas fee at the
I'm for the response case. Lordship may call the order dated 15/2023, my lord.
Appears for the petitioner. There is a non-compliance to the order dated 15/2023. Accordingly, writ petition stand dismissed.
Serial number 19, Krishna Kumar Prasad Chaudhary versus Central Bank of India and others for the petitioner Krishna Kumar.
Dismissal.
Yes, ma'am.
Dismissal from service.
My lord.
Where are the regulations?
The regulations. My lord, it appears in this case also there is an order for producing the record, but that record was lost because of that fire. Therefore, on the materials for your lordship's review.
Is the clause relating to initiation of proceedings?
No, sir. 4, my lord.
Page number?
Page number. No. Procedure for imposing major penalty 6, clause 6, my lord. Page number.
Huh?
I don't know whether it has been marked or not, but it is. I have marked with pencil 24. I don't know whether it is.
Where is the procedure for imposition of major penalty?
That is clause 6. First is there.
Where is the charge memo?
Mr.
Clause 2 has been struck down or what? Why it has been struck down?
6.
Subclause 2 of clause 6.
This is structure. Regulation 6(2) first amended. That is written below in the amended by national regulations. Again amended on the amendment. The contents are same, but effective date given in as 3/3/2001 for regulation 6(2) and amended version is as under. Now the next is clause 2. The amended version is whenever there is disciplinary authorities of opinion that.
Where is the charge memo? Charge memo.
40, my lord, page 40 of the writ petition. Page 40.
Complete set is annexure 8, my lord, at page 257 to 93. Annexure.
Annexure 8 is the inquiry report, if I am correct. Annexure 6,
my lord, annexure
at
6.
page 14.
Sorry, my lord. 40 to 58.
Annexure 6 is supplementary charge.
My lord. But it is in continuation. Annexure 6.
What is wrong with the disciplinary authorities order dismissal?
My lord. And the appellate authority, without giving any cogent reason, dismissed the appeal.
Cogent reason.
My lord, it was a formality.
Where is the dismissal order?
Appellate authority.
Huh? Where is the dismissal order?
My lord, annexer, it is in the appeal separate. I think the separate order has not been.
Are you appearing for the petitioner?
My lord.
You don't know where is the dismissal order?
Next
My lord.
at page 2294.
Have you furnished dates and events?
My lord.
Where is that? At least from that, can't you make out and say?
My lord, it is annexer 9, my lord.
Annexer 11.
9. And appellate order is annexer 11.
Annexer 9, page number?
294 to 324. 294 to 327.
On what basis you are saying there is no cogent reason?
My lord, in the appellate order.
The authority,
in the appellate order, my lord. Annexer 11.
Appellate authority has not given reasons.
My lord. He has observed a hollow formality, my lord. It is the relevant part is at page 337, last paragraph. I have gone through the said submissions of the appellant in detail, vis-a-vis the case record, and observed that the said aspects have already been dealt with in detail both by the inquiry authority and the disciplinary authority. The appellant was given ample opportunity and justice to defend himself in the case, and he did avail himself of the same. Now, what being appealed is to interpret the facts in a different way. The inquiry authority and the disciplinary authority have dealt with the various aspects of the case in a very detailed manner and left no scope for any interpretation otherwise. In fact, the nature of evidence laid in the case is direct and self-explanatory.
Is the appeal provision? Everything we have to assist, is it? Regulation number 17.
Officer may appeal against an order imposing upon him by any of the penalties specified. The appeal shall lie to the appellate body, and appeal shall be preferred within 45 days from the date of receipt of the order appealed against. The appeal shall be addressed to the appellate authority and submitted whose order is appealed against. The authority whose order is appealed against shall forward the appeal together with its comment and record of the case to the appellate authority. The appellate authority shall consider whether the finding.
Where is that? From the appellate authority. The appellate authority shall consider whether the findings are justified or whether the penalty is excessive or inadequate and pass appropriate orders. The appellate authority may also pass an order confirming or enhancing or reducing, setting aside. It is not a speaking order.
Since it is in the appellate authority is an order in agreement.
That's all. But he has not, though he refers to each of the contentions, but he has not dealt with how it is relevant and how it is not relevant.
Parts of the case thus substantiate at the end, my lord, the charges appearing against the appellate at the disciplinary authority concerned as
What is the age of the
petitioner?
What is the age of the petitioner?
Attained the age of superannuation, 2010.
How can you say that he has attained age of superannuation when he has been dismissed from service?
Well,
एज आप एज बताइए.
I will remand the matter to the appellate authority. What was the post held by him as on the date of dismissal?
My lord, he was branch manager, scale 2.
Branch manager?
Scale 2.
What is meant by scale 2?
Scale, my
One
lord.
is the initial officer grade, and then the second post is scale 2, scale 3, scale 4.
Taken in the instant petition petitioner has prayed in the instant petitioner has prayed for the following relief. The petitioner by working as a branch manager, scale 2. At which place?
At Jasauli, East Champaran. At Central Bank of India, Jasauli branch, East Champaran district.
Jasauli branch.
My
He has alleged to have committed certain misdeeds when discharging the functions of the post, for which he was subjected to disciplinary proceedings.
At the time of initiation of the proceeding, Lord, he was lead bank manager Muzaffarpur, but then previously branch manager Jasauli branch.
No, the allegation is Jasauli.
Jasauli, related to Jasauli.
Initially overall, seven charges were prayed. Thereafter, supplementary charge was also.
Seven and plus 1.
Charge number 1, 2, 1, 2, 3, 6 and 7. And the supplementary charge were held to be proved. And charge number 4 and 5 were proved in part. The disciplinary authority, after due compliance of procedure down in the Central Bank of India officers, employees, within bracket conduct regulations 1976, proceeded to impose the penalty of removal.
Conduct regulation.
Removal or dismissal?
Conduct regulation is only for the conduct. Then the next is the discipline and appeal regulation 19 at page 20. This is first regulation is only conduct, and the second regulation is the Central Bank of India Employees Discipline and Appeal Regulation 1976, under which the penalty was passed and the appellate authority was passed.
Then you take read with, where is the title second?
Second is at page 20. I don't know whether I have marked in such. I am giving my copy, Lord. It is marked by pencil.
Read with Central Bank of India officers, employees within bracket discipline and appeal. Bracket close the regulations from 1976. Order of penalty of removal.
My lord.
Removal has been ordered.
Dismissal है altogether.
In your list of dates and events, you have shown removal. There is a lot of difference between removal and dismissal.
My lord, it is dismissal.
The dismissal. All right. Dismissal.
With a bar for future employment.
No, not be ordinarily be disqualified.
Feeling aggrieved and dissatisfied with the order of dismissal, petitioner submitted memorandum of appeal before the appellate authority on 23/1/2009. The appellate authority confirmed the order of dismissal dated 26/11/2008 on 15/12/2009. Hence, the present petition. Mr. Counsel for the petitioner restricted his argument only to the extent that appellate authority order is not in consonance with the principle of Regulation 17. Full stop. Therefore, appellate authority order is liable to be set aside by remanding the matter to the appellate authority to consider petitioner's memorandum of appeal afresh. Who is the percontrol and counsel for the respondent try to defend the action of the appellate authority. Who is heard the land counsels for the respective parties. It is necessary to reproduce Regulation 17 dash appeals of Regulations 1976, which reads as under. The appellate authority was required to consider the memorandum of appeal and other issues as stated in the Regulation number 17 of Regulations 1976. The appellate authority order is a breadth of reasons. The appellate authority has only restated the facts of the case and extracted the contentions of the petitioner in the memorandum of appeal, and thereafter proceeded to confirm the order of the disciplinary authority, as is evident from page number 1-2 of the appellate authority order. Therefore, it is a case for a remand. Accordingly, full stop. Next paper. Apex Court. The case of Victoria so and so held that orders which are amenable to judicial review was required to be order. To stop. In the present case, appellate authority order is not a speaking order with reference to each of the contentions narrated by the petitioner in his memorandum of appeal, and so also it has been extracted by the appellate authority. So accordingly, order of the appellate authority dated 12/2009 is set aside and matter is remanded to the appellate authority to pass order within a period of 3 months from the date of receipt of this order. The petitioner is permitted to file additional grounds in support of memorandum of appeal, if any, within a period of 1 month from the date of receipt of this order. So the concerned appellate authority is hereby directed to consider, in the event of filing additional grounds in support of memorandum of appeal, petition stands forward in part.
Serial number 20 is passed over for the date. Serial number 21, Jitendra Kumar Singh versus the Union of India for the petitioner Union to Maharashtra.
Thank you, Lordship. Pursuant to the order dated 27/2022, I filed an interlocutory application.
The authority has filed affidavit?
Yes, Your Lordship, right.
Same, presenting officer.
Vice.
Make a dictation.
Yes. Your Lordship, same matter. Yeah,
We will allow in the light of LPA decision.
no option.
Huh?
We have no option other than.
You are not?
We have no option other than that.
All right. Third, in the instant decision, petitioner has prayed for the following relief. On 20th July 2022, following order was passed. So, learn counsel for the respondent has vehemently contended that presenting officer, appointment of presenting officer is not part and parcel of rules to stuff. In identical matter, this court in the LPA number so and so held that presenting officer in a departmental inquiry is mandatory. So, therefore, in the light of order passed in the repetition stands allowed, matter is remanded to the disciplinary authority to decide the disciplinary proceedings afresh from the defective state, namely in appointing presenting officer to present the departmental case before the inquiring authority. And conclude the departmental inquiry within a period of 6 months from the date of receipt of the order. Accordingly, annexure so and so stands aside. The writ petition allowed in part.
Obliged.
Serial number 22, RP Kanpur versus the Chairman of MD Eco Bank for the petitioner Shah.
Lord, this application is directed against the order of punishment.
Punishment? What punishment?
Lord, reduction in rank And
Reduction in rank.
From
what post to what post?
From senior administrative grade to senior administrative grade to junior of the administrative grade in the bank.
Senior
Administrative grade. Annexure 1 is the impugned order, my lord. At page 44, your lordship will.
Senior to junior.
Yes.
Junior or administrative grade?
Administrative grade. My lord, your lordship will kindly see.
You are promoted to the post of senior administrative grade?
Yes. My lord, when the case was pending, my lord, the petitioner died. He was substituted. Then, my lord, I will request your lordship to kindly have a look at the order dated 26/6/2015, order number 9. But this court has taken note that now since the petition.
Order number?
Yes, my lord. Dated 26/6/2015. The first page is irrelevant because now, my lord, in this case,
The legal ground is there?
Yes, my lord.
By interfere, otherwise I will not.
Yes, your lordship will find that in this case, the only ground, my lord, which I have taken, that right from the very beginning, my lord, I was making an application before the authorities that the inquiry officer should be changed. That is what changed because he was prejudiced. My lord, that
What is the date of appointment of inquiring officer?
inquiry officer slipped to find. I'm just giving to your lordships. In fact, my lord, Annexure 3 is the charge sheet. Annexure 5 is the.
All right, sir, please answer. What is the date of appointment of inquiring officer?
Inquiry officers. The report is dated 22/1/2007, but charge sheet was dated 5/4/2006. That is not Annexure 3. Lord, I have provided.
Answer to the court question. If you don't have answer, please say. I don't have.
No, Lord,
Don't circumvent the court
the
question.
date of the inquiry officer's appointment, Lord, has not been.
Sir, we want to know what is the date of appointment of inquiring officer. Because you have raised the issue that he is biased against you.
Yes. That, Lord, your lordship will find from Annexure 5 itself.
Don't ask me to find out. Find out what is the date.
This is, Lord, dated 14th of September 2006.
14th of September?
2006, the application was filed. And
No, the date of appointment of inquiring officer. This is third time I am repeating.
Lord, I have got it, Lord. Yeah. The charge memo is. The thing is that since he is dead. Charge memo, my lord, is at page 45.
What is the court is asking you?
The irregular allotment of funds.
No, what is the court is asking you?
Because the court is asking.
Provide the
date of appointment of the inquiry.
Say I have or not.
I have got.
Say,
Yes.
Be frank.
Yes.
Then we'll examine. Yes, where is the order of appointment?
My lord, page 13 of the counter update notification dated 22/8/2006. 22/8/2006. 22nd of August 2006.
Appointment of inquiring officer.
My lord.
For the first time, petitioner has raised the bias against inquiring officer on what date?
Yes, that is I am giving you lordships. Annexure 5 that is dated 14/9/2006. 14/9/2006.
Where is the document?
Annexure 5, my lord. And this issue was also raised before the appellate authority by Annexation 9.
All right, sir, I will get up and go. If you are jumping the facts of the case.
Annexure 5 at page 61.
You are a designated counsel, senior counsel. Who is your, whether disciplinary authority has taken any action on this?
No.
No?
No finding on this. No action was also taken. And this was not.
What is the bias against him? The inquiring of the authority?
I was directly working under him, and he had a bias because I was direct under him in the bank. In the
So mere working directly under him does not amount to bias.
The bias
was there any confrontation, some incident between?
That there was, but the only thing is, Milord, that I am handicapped fact that since the petition is dead, that I cannot take any instruction as to what had happened.
But you are not in disclosure. You means petitioner has not disclosed in Annexure 5. To what extent?
But that is the first time the application was made. And the same thing was not taken at the Annexure 9 itself. In the appellate.
Was one incident that the petitioner has petitioner.
This I cannot show to the lordships because I have said that since he is dead, I could become your lordship.
All right, that's all.
Another time.
All right, that's all. Take up. In the instant petition, petitioner has prayed for the following relief. The petitioner, while working as a senior manager,
No, he was only manager. Manager. He was only manager.
Manager, Sabor branch, STABOUR. He was subjected to disciplinary proceedings in framing article of charges on 5/4/2006. Petitioner had submitted his explanation on 24/4/2006, denying the alleged charge. During the pendency of the inquiry, he had submitted for change of inquiring officer on the score that inquiring officer is biased against petitioner. Such a request was made to the disciplinary authority on 14/9/2006. No doubt, disciplinary authority has not passed any order either accepting or rejecting. At the same time, before conclusion of the departmental inquiry on 22/1/2007 in submitting the inquiring officer's report, the petitioner should have invoked remedy before this court so far as change of inquiring officer. Further, it is noticed that request for change of inquiry on 14/9/2006 is not substantiated by any event like a scuffle, like a oral altercation or any incident among the petitioner and among the deceased petitioner and the inquiring officer, who is clearly alleging bias in the absence of any event. One cannot draw inference that inquiring officer was biased against the deceased petitioner. Full stop. Thereafter, the inquiring officer submitted his report on 22/1/2007. The result, a second show cause notice was issued and the disciplinary authority proceeded to impose the penalty of reduction in rank from the post of a senior administrative grade, administrative officer grade to that administrative officer who is feeling aggrieved and dissatisfied with order of penalty deceased petitioner preferred appeal on 23/7/2007 and it was rejected on 8/8/2008. Hence the present petition. The senior counsel, Mr. So restricted his argument only to the extent that deceased petitioner has raised bias against the inquiring officer. No other allegation has been raised other than biased ground. It is necessary to reproduce the Annexure 5 dated 14/9/2006 insofar as raising the issue of bias against the inquiring officer. So, perusal of the letter dated 14/9/2006 of the petitioner, deceased petitioner, it is evident that very vaguely contention has been taken that the inquiring officer is biased. In other words, in the absence of any alleged incident among the deceased petitioner and inquiring officer, one cannot draw inference that the inquiring officer is likely to be biased against the deceased petitioner on the sole ground that deceased petitioner was working under the inquiring officer. During pendency of the present petition, the petitioner has died and alerts have been brought on record. Next, in the light of these facts and circumstances, question of interference or a judicial review in a disciplinary proceedings is not warranted in the light of Apex Court decision in the case of State of Karnataka versus Umesh, reported in 2023, so and so. Accordingly, writ petition stand dismissed.
Because being a lordship request one thing, that in the memo of appeal also he has taken this specific point, and the honorable single bench by order dated order number 9, his lordship has said that they have to produce the record because their lordship was wanted to see.
That is not binding on me at the time of taking final.
That I am just bringing to your lordship's notice the order below the import why the honorable judge below says that the record should be produced. Because whether what the question your lordship is putting below, it is very difficult for me to say at this stage what has transpired. His lordships wanted to know whether there was any such incidents or report to the inquiry officer or to the disciplinary authority. So therefore, I wanted.
No action has been taken on your representation.
Yes.
You had a cause of action to approach this court.
Yes, your lordship is correct, but I had taken the approach before the appellate authority. Yes. The appellate authority also did not pay any attention to it. So therefore, I had come to your lordships.